Hello and welcome to Win Without Law School. I'm Arizona lawyer Julie Labenz. Today we are going to be talking about temporary orders for a child custody establishment case. So this is a case where two people have children in common, they never got married, they've split up, they're not living together, and there's a need to get an order in place while the case is pending. So let's talk about temporary orders. We're first going to cover what a temporary order is. Then we're going to talk about a temporary order with notice. Next, we'll talk about responding to a temporary order, replying, and then the RMC evidentiary hearing, what can happen if the matter remains contested. Now, there's motions for temporary order with notice and without notice, and we're going to cover both of those in part 2. Part 3 and 4, the response and the reply, that's going to cover, or that's going to apply to the motion with notice. For the procedure without notice, it goes so fast there really isn't time to do a reply and a response. And if you go the without notice route, then you still need to file a motion with notice, because if you get an emergency temporary order, it's only good for about 10 days and then it expires. And so if you want it to keep going, you have to file a motion with notice. And then that's when the response and the reply will come into play. Otherwise, you can just initiate the case for a motion for temporary order with notice and follow the main procedure. So we'll cover that in more detail, but there are 2 types of temporary orders, with or without notice to the other party. All right, what is a temporary order? It's an interim order issued by the court to address issues that need to be addressed while the case is pending, such as legal decision-making, parenting time, and child support. So sometimes a case can take 6 months, a year, or longer to get resolved. But in the meantime, the parties need to know what's the deal with decision-making for the kids? What's the parenting plan? What's the deal with child support? So instead of waiting until the case is over, the law allows either party or both parties to go to the court and request a temporary order to resolve these disputed issues on a temporary basis. There's this statute 25-404, and this talks about temporary orders. And I wanted to point out here that the court may award temporary legal decision-making and parenting time under the best interests of the child standards after a hearing, or if there is no objection, solely on the basis of the pleadings. So I just want to bring that up, that there is this option that if the other side does not object, there doesn't have to be a hearing and the temporary order can be entered by the court. So if, let's say, you serve the other side and they just don't respond and they don't show up to the hearing, or they don't show up to the RMC, depending on what's set, the court could, based on this statute, just enter what you're requesting on a temporary basis. What temporary relief can you request in a motion for temporary order? Now, we're in the custody establishment context, so you can request a temporary legal decision-making order. So this is going to be for joint or sole legal decision-making. This will need to be requested in your motion or in your response, depending on who's making the request for the temporary order. But you'll need to indicate, are you requesting sole decision-making? Are you requesting joint? Are you requesting joint with final say if there's a dispute? Are you requesting joint on most issues, but sole on one of the issues, such as education? If you want more direction on legal decision-making, look at the case strategy creation videos. Those will give you more detail on sole versus joint legal decision-making. But the bottom line is, for a temporary order for legal decision-making, it needs to be sole or joint, and there can be some of those carve-outs where there's final say or sole on 1 or 2 issues. That's definitely a possibility. Also, Temporary orders can cover temporary parenting time. So what is the schedule for when each child will be with each parent? What is the pickup drop-off time? What is the pickup drop-off location? All of those details, what happens during holidays, what happens during school breaks, all of that should be covered in the temporary parenting time order. The more detailed you are with your parenting time order, the less you need to communicate with your co-parent about all of the details. So a detailed parenting time order, even on a temporary basis, can be very helpful. And then temporary child support. So what is the amount that one parent's going to pay the other on a temporary basis while the case is pending? As I mentioned earlier, there are two options for a motion for temporary order. There's with or without notice to the opposing party. Standard procedure is to seek a temporary order with notice to the opposing party. Because in order to qualify for a temporary order without notice, which is also called an ex parte motion for temporary order, you must show irreparable harm and why you could not give the opposing party advance notice. So there's this burden of proof that you have to meet to qualify to file a motion for temporary order without notice. So the majority of cases are going to go this with notice route. The only time you're going to seek the without notice is if there's some danger on the horizon. There's some threat of irreparable harm to you, to the child, to property, and there's a reason why you shouldn't give the opposing party advance notice of you seeking the order, and instead the court should only hear from you, so ex parte, not hear anything from the other side, only hear from you, potentially issue the order, and then give the other side a chance to tell their story about 10 days later. So with notice is going to be the most common. That's most likely what the avenue you're going to go down. But if you're in this situation where there's the potential for irreparable harm, then the without notice is an option. But as I mentioned earlier, if you go the without notice route, you're still going to have to follow the with notice procedures, because the temporary order that's issued without notice expires in 10 days. It could potentially be extended for good cause, but in general, it expires in 10 days. And so if you want the terms of that order to continue, you need to file a motion with notice. All right, so we'll cover that in more detail today. Also keep in mind, let's say you don't qualify for the without notice. You don't have the irreparable harm, but there's still something going on where you need the court to issue a temporary order as soon as possible. If that's your situation, you can ask for expedited relief. So this is under Rule 47H of the Arizona Rules of Family Law Procedure. And it explains that if a party requests an expedited hearing, the caption of the motion must include the words expedited hearing requested. And then the motion must specify the facts necessitating an expedited hearing. So for example, we're arguing about school and a decision needs to be made. So I need to get sole decision making on education as soon as possible so I can get my child enrolled in school on time. Expedited hearing requested. Something where there's some pressing issue that needs resolution and you need the court to give you expedited relief. But if there isn't anything pressing and you don't have irreparable harm, then you'll just file a regular motion for temporary order. All right, let's talk some more about this option of the temporary orders without notice. A party may request a temporary order without notice by filing a verified motion, along with a proposed form of order and a notice of hearing on the motion. A motion may be filed at the same time or after filing an initial pre-decree or post-decree petition. So what this means is when you initiate your custody establishment case, at that time, you can also seek a temporary order with or without notice, or you could do it anytime after you initiate your case. A court may grant temporary orders without written or oral notice to an adverse party or that party's attorney only if the verified motion clearly shows by specific facts that if an order is not issued before the adverse party can be heard, the moving party or a minor child of the party will be irreparably injured, or irreparable injury, loss, or damage will result to property of the moving party. Now, this property part is going to apply more in divorce cases. So most likely, if you're seeking an order, a temporary order without notice in a custody case, that's not going to be your main claim. It's possible, and the language is here, but in general, that's more going to be in a divorce matter. And instead, you'll be looking at this irreparable injury to the moving party or a minor child. So you'll need to establish facts. What is this irreparable injury? And then why should you not have to give notice? Or what efforts did you make to give notice to the other party that you were going to the court ex parte to get this temporary order? Temporary orders without notice must specify the injury, loss, or damage and why it is irreparable. So what this is saying is, if the judge is going to issue a temporary order without notice, then in the temporary order itself, the judge has to specify the injury, loss, or damage and why it is irreparable and why the court granted the orders without notice. The temporary orders without notice expire at the date and time set for hearing on the motion unless the court extends the time for good cause. Generally, that is 10 days after. So keep in mind, a temporary order without notice is only good for a limited amount of time. An evidentiary hearing must be set on the motion not later than 10 days after the order's entry, unless the court extends the time for good cause. The non-moving party can request an earlier date, so earlier than 10 days, if they choose. The order and notice of the evidentiary hearing must be served as soon as possible after the court's entry, or after the order's entry, or as the court directs. And then no bond is required unless the court finds it appropriate. So this is additional rules about temporary orders without notice. Now, I also want to bring to your attention that there is this separate procedure for child support orders. So this is if you are only requesting temporary child support, you can take advantage of the simplified temporary child support procedure. To do so, you'd file a verified motion for simplified temporary child support order, a completed child support worksheet. That's also going to include proof of your current income, a proposed simplified temporary child support order, and a proposed income withholding order. Now, I want to go back to subsection B, the completed child support worksheet. In there, you're going to propose gross incomes for each parent. And so attached to your worksheet, you need to have documentation substantiating the numbers you used in your worksheet. For more information on that, go to the simplified child support video in the modification section. Required disclosures: the moving party must serve the motion with the proposed simplified temporary child support order and proposed income withholding order. The motion must advise the responding party of a requirement to file a timely response and a completed child support worksheet, and must advise the responding party that failure to do so may result in the court entering the requested temporary child support order. So this procedure is different, and this is why it's called simplified, is because you file the papers, and if there's no objection within a certain amount of time, then the court can just enter the order. And then the moving party can request a hearing, and if they do, then they need to give the responding party notice of the hearing. And the motion must be served on the responding party by affidavit of service, certified mail, restricted delivery, or a process server, and the moving party must file their proof of service. The responding party must file a response not later than 20 days after they've been served, if they were served in Arizona, or 30 days after they were served, if they were served outside of Arizona, and then they can request a hearing, and they have to serve the other side with a copy of their hearing request. And that would be by mail, just regular mail for that service. And then uncontested, if the responding party does not file a response, or if the response does not contest the child support requested in the motion, the court will not set a hearing. The court will enter the proposed simplified temporary child support order and income withholding order if the available information in support of the temporary order appears accurate and provides the court with adequate information to determine the amount of child support under the Arizona Child Support Guidelines. So if your paperwork is sufficient and the other side doesn't respond, or the other side doesn't contest what you request, then the court can just enter the order. Now, I just want to bring us back to where we are here. This is an additional option for a temporary order if all you're asking for is child support. So you're not asking for legal decision making, you're not asking for parenting time on a temporary basis, you're only asking for child support. This is one option to pursue only child support. Okay, now I want you to keep in mind the procedure for temporary orders with notice. First, you file your motion for temporary order. You include a proposed temporary order and the order to appear. Now, there's a couple of additional documents. You're going to have your proposed parenting plan if you're seeking a parenting time order on a temporary basis. And you're also going to have your proposed child support worksheet if you're requesting temporary child support. So your motion, your proposed order, your proposed parenting plan, your proposed child support worksheet, and then your proposed order to appear. And we're going to go through those pleadings. Once you file, then you're going to serve the documents that you filed. Now, the service, because there's an order to appear with a court date in it, the service is a bit more formal. So it's that affidavit of service, it's the acceptance of service, affidavit of service by certified mail, or you can hire a processor. And then once the motion's served, the other side, the co-parent, they can file a response. And then once a response is filed, the party that filed the motion, they have the opportunity to do a reply to the response. The matter generally proceeds to a resolution management conference. And then if there's remaining disputed issues, it can go to an evidentiary hearing. So this is the with notice procedure. And then here is the without notice procedure. So I want to show you the differences here. In step one, you file your ex parte motion for temporary order, your proposed temporary order, and your proposed order to appear. If the court, like at the time you file your documents, the court can call you into the courtroom and have you testify right there, or based on the pleadings alone, the judge can enter the order or the court can deny it. So the judge will decide how to proceed, and ultimately the judge will make a ruling to enter the temporary order without notice or not. If the temporary order without notice is issued, then the party that requested it is obligated to serve their co-parent with the motion, the completed temporary order that the judge has signed, and then the order with the court date called the return hearing. They have to serve that, and they need to serve it really fast. And you likely need to hire a processor because of the short deadlines. The other options likely aren't going to work for you. Prepare for the return hearing and then conduct the return hearing. And also, in the meantime, you're likely going to need to file a regular motion for temporary order with notice if you want this temporary order that you got without notice to stay in place for longer than the 10 days, for longer until it gets to the return hearing. Okay, so now we're going to look at the pleadings that are involved. All right, so for a motion for temporary order with notice, you're going to file the motion, the proposed parenting plan, proposed child support worksheet, your affidavit of financial information, proposed temporary order, and then the order to appear. And then in certain counties like Yavapai County, you also have to do this additional document called petition for order to appear. So the motion itself, this is the motion with notice, and this is going to be a request for temporary legal decision-making and parenting time, temporary child support, the affidavit of financial information. Now, you may have already filed that in your case. Maybe you filed that when you filed your petition or when you filed your response. And if that's the case, you would only file a new affidavit of financial information if something had changed, if you needed to update the numbers or the information in that affidavit of financial information. And then your proposed order and the order to appear, possibly also a petition for order to appear in certain counties. Okay, so this is with notice. And here is the motion. So motion for temporary orders, you're going to check everything that you're requesting. And what you're going to find with this standard form out of Maricopa County is that this is also for divorce cases. So you're going to see that in this standard form, there's going to be a lot of stuff that doesn't apply in your custody case. But these top 3 boxes can apply in your case: legal decision-making and physical custody, parenting time, child support. So check all the boxes regarding the relief you're requesting on a temporary basis. And then if you are also requesting attorney's fees for whatever reason, you can also check that box. Okay. Now, once you have filled out your caption, this is going to look exactly like what's in the petition to establish or in the response to establish decision-making, parenting time, and child support. You're going to have the same petitioning party respondent in your case number. Pick out what you're requesting temporary orders for, and then start filling out the document. Now, all of this is going to apply to a custody establishment case. So fill all of this out. And then here's the parenting plan. So that's where that can be either attached, or you can do it as a separate filing. So you could scratch this out and say, I contemporaneously filed. That's how I would say it as a lawyer. But you could say I filed at the same time I filed this motion, I filed a proposed parenting plan. I describe specific legal and physical custody plans in the proposed parenting plan. So that's great. So fill all of this out. This is all stuff that's going to apply in a custody case. So that was decision making. Here's parenting time. Fill all of this out. You can also check this box instead of filling this out and say, in accord with, either attach your proposed parenting plan, or say with the contemporaneously filed, or with the filed, or with the parenting plan I filed. You can modify this sentence. And then the child support you're requesting, if you're requesting a deviation, your request for healthcare coverage for the minor children, so medical, dental, vision care, insurance for the minor children, how uncovered medical expenses will be divided between the parents. Now, this part here, this is not going to apply. This is for divorce cases. So spousal maintenance, property debt. This is for divorce or legal separation. So you don't need to fill any of this out. Now, if you're requesting an award of attorney's fees, you can fill that out here. How long you want the order to stay in place, and then you can sign in front of a notary. Here is what the proposal for legal decision-making and parenting time looks like. So this is the parenting plan proposal. I only included page 1. I've gone over this document in some of the other videos leading up to this video. The full document is attached below, but you can access the legal decision-making and parenting time case strategy video where I'll go through this entire document. But this is what it looks like, just so you know what I'm talking about. This is the parenting plan. It's 10 pages long. And then the child support worksheet. So this is a blank one, And you're going to fill this out and have it show exactly what you're requesting. So this should be all filled out with the numbers you're proposing to use for each party's gross income, everything, and then the final child support amount. So if you need help filling out the worksheet, go to the child support case strategy creation videos, and that'll walk you through how to use this document and how to fill it out and how to get a child support amount. Then we've got the affidavit of financial information. So this is a 12-page document. This is about your income and expenses and your employment history. So this is a long document, fill this out, but anytime that child support is at issue, this document's going to need to be filed. Also, if either party is requesting attorney's fees, this document gets filed in that event too. All right, this is what the proposed temporary order with notice for legal decision-making, parenting time, and or child support looks like. So again, this is a standard form from Maricopa County that applies in divorce cases as well. So don't worry about the spousal maintenance support or the property and or debt, but check the boxes for the type of orders you're requesting: legal decision-making, parenting time, child support, attorney's fees. Fill out the caption, fill out your case number, and then start filling out what you want the court to order. So fill this out with what you want the court to order in the temporary order. So legal decision-making, parenting time, child support, health care coverage for the minor children, uncovered medical expenses. And then this is, you don't need to fill this out. This is all divorce stuff. That's all divorce stuff. Any request for attorney's fees, you can indicate that here, what you want the court to order, and then leave the rest blank because the judge is going to fill this part out. So the judge can make changes if the judge ultimately doesn't agree or doesn't, award you what you're requesting. But this makes it very easy by providing the judge with an order that matches up with exactly what you're requesting, and all the judge has to do is sign. The court does want, and the rules want you to provide the court with a proposed order. So this is a requirement, and it should be filled out with your requested outcome. All right, next we've got the order to appear. So this is a document that you're going to only fill part of it out. You're going to fill out the caption and your co-parent's name, but that's it. The court will fill the rest out. If you are in Yavapai County or in some of the rural counties, you'll also need to do this petition for order to appear. So you'll fill all of this out, sign it, and then this is the order to appear for pre-judgment temporary orders. So you'd fill out the caption and you'd fill out the name of your co-parent, and then the court would fill out the rest of this document. And what the court is filling it out with is your court date for the hearing on the temporary orders. So here's a summary, just a review of the papers to file if you're seeking a motion for temporary order with notice. So number one is the motion itself, the proposed temporary legal decision-making and parenting plan, the proposed temporary child support worksheet, affidavit of financial information, proposed temporary order, and then the order to appear, which is what the court then puts the hearing date in. The order to appear gives you the hearing date on your motion, which usually the first hearing date is called a resolution management conference. So we'll talk about that more in today's presentation. What are the next steps after you file your motion for temporary orders? Again, we're in the with notice arena. So you file your motion and the associated documents. Then the court will issue the order to appear with a court date for resolution management conference. And we'll provide you a copy of the completed order to appear with the court date for the resolution management conference. And you'll have court stamped copies of all your documents. When you receive the completed order to appear, then you need to serve your opposing party with your motion for temporary orders, your proposed parenting plan, your proposed child support worksheet, your affidavit of financial information, your proposed temporary order, and the completed order to appear. Once the papers are served, the opposing party has 10 business days plus 5 straight days to file a response to the motion for temporary orders. Upon filing and service of a response to motion for temporary orders, the party that filed the motion has 5 business days plus 5 straight days to file a reply to the response. So the response, let's say, is filed on January 1st. You count 10 business days from January 1st, and then 5 straight days, and that's the deadline to file your response. For the response, it's filed, let's say, on January 10th. You then count 5 business days from January 10th, and then 5 straight days, and that's your deadline to file the reply to the response. Upon receiving the motion for temporary orders and the required supporting documents, the court must schedule a resolution management conference. At the RMC, no evidence is taken unless the parties agree, and the purpose is to facilitate agreements between the parties that permit the entry of temporary orders at the conclusion of the conference. If, at the end of the RMC, there's disputed issues that still remain, then the court can schedule an evidentiary hearing on those issues. If the court finds that the circumstances of a specific case demonstrate that an RMC would not serve the interests of efficiency, the court can just immediately schedule an evidentiary hearing. And the court must set the conference or hearing not later than 30 days after the motion is filed. The court may not resolve disputed issues of fact at a RMC without the parties' agreement. So the court wants the two sides to try to resolve temporary legal decision-making, temporary parenting time, and temporary child support at the RMC if possible, either at or before the RMC if possible. And if the parties aren't able to do that, then an evidentiary hearing will get set on the disputed issues. Now, if in your motion for temporary order, you requested expedited relief and you explained why that was merited and the court found your arguments persuasive, then the court could skip setting the RMC and just set an evidentiary hearing. If all of the issues are not resolved at the resolution management conference, the court must set an evidentiary hearing not more than 30 days after the RMC. The court may extend deadlines for good cause shown, and for any temporary parenting time order entered under this rule, the court must determine an amount of child support. So keep in mind that if you request only temporary parenting time and that's it, the law actually requires the court to order child support if a child support award is merited. So just, I don't mean if it's merited, basically if there's an amount owed pursuant to the child support guidelines, the court is supposed to enter that if temporary parenting time is entered. Okay. Service of process. So the order to appear is issued. You receive it. You must act promptly to complete service. You must serve your co-parent with your motion, your proposed parenting plan, your proposed child support worksheet, your completed affidavit of financial information, your proposed temporary order, the issued order to appear with the court date, and you have 5 days after receipt of the issued order to appear to complete service. So you're supposed to do this really fast. Ultimately, you must complete service not later than 14 days before the hearing date. So the bottom line is once you get that issued order to appear, you need to immediately start working on service. Your service options are: number 1, the acceptance of service. This is where you meet with your co-parent and a notary or court clerk, hand your co-parent a copy of your motion for temporary order, your proposed parenting plan, your proposed child support worksheet, your AFI, your proposed temporary order, and the completed order to appear. Your co-parent signs the acceptance of service form before a notary public or a court clerk. And then service is complete upon you filing the signed acceptance of service with the court. A second option is certified restricted mail. So in that case, you would mail the 6 documents to your co-parent. And then it looks like I put 5 here twice, so I need to correct that. You would mail the 6 documents to your co-parent via certified restricted mail so that only your co-parent can sign the green card. If they sign the green card and it comes back signed, then you file that with the court using an affidavit of certified mail, also called an affidavit of signature confirmation. And then the final option is a process server. And the service is complete upon the filing of an affidavit of service. All right, this is page 1 of the acceptance of service form. The full form is below this video. So just fill this out and keep in mind that once this is signed by your co-parent and they've received the papers, this document, you need to file this document with the court. Here is what's called the affidavit of service with signature confirmation. This is also known as the affidavit of service by certified mail. And so this is page 1 of this form. The full form is down below. So you'll just fill this out. And on the final page, you'll include a copy of the signed green card and a copy of the receipt that shows where the documents were sent. Process server form. So this form is not filed with the court. This is just an example of a form you can give to a process server, in particular, a police department, if you hire a process server. So you'd fill this out. You can see this is for a county sheriff and provide them with this information. If you hire a private process server, they'll likely have their own form similar to this that you'll fill out. All right, so this is the procedure for temporary orders with notice. You file your motion and the supporting documents. You serve your motion and the supporting documents with the completed order to appear. And then the other side can file a response. You can file a reply to the response, and then the case proceeds to a resolution management conference. If all issues aren't resolved there, then it goes to an evidentiary hearing on the remaining disputed issues. The procedure for temporary orders without notice is different. You file your motion, the judge makes a ruling about whether or not to issue the temporary order without notice. If it is issued, you must serve it very quickly. There's a return hearing that's usually in about 10 days. And then at the return hearing, the court decides whether to keep the order in place. In the meantime, you're supposed to file a motion for temporary orders with notice if you want to keep the order in place beyond the return hearing. So let's talk more now about temporary orders without notice. So just remember that you need to file certain documents, and then you have to show that you qualify, that there's going to be some sort of irreparable injury, and that you tried to give the other side notice and weren't able to, or why giving notice to the other side should not be required. And then remember that temporary orders without notice expire at the date and time set for the hearing on the motion unless the court extends the time for good cause. And what's called the return hearing on the motion for temporary orders without notice, that's supposed to happen not later than 10 days after the order's entry. That's going to be 10 business days, unless the court extends the time for good cause. And the non-moving party can request a hearing date earlier than the 10 days. The papers need to be served as soon as possible, so you likely are going to need a process server if you received a temporary order without notice, and then no bond is required unless the court requires one. Let's look at the form for a motion for temporary order without notice. So this is the Maricopa County form. Fill out the caption. This is a motion for pre-decree temporary order without notice for legal decision-making and physical custody. So you'll see here on a temporary basis, and given this irreparable harm issue, the court isn't getting into child support. This is just for legal decision-making and physical custody. So you'd fill out this form, explain who's involved, explain why you didn't give notice or why you weren't able to, or why you don't think notice should be required. And then fill this out. So this is, you know, I was talking about how if you go this without notice route and you get your order, you're still going to have to file a temporary order with notice. And so this is indicating I already filed it, or I will file it by a certain date. And I've attached a copy. And I have attached a copy to the judicial officer's copy and to the other party's copy of this motion. Or I have not filed it, and I understand that this order is going to expire. And if no temporary orders with notice have been issued by the court before these orders expire, no court order will be in effect. So fill this out depending on what you're requesting. Now, this is for divorce, but here is the petition to establish legal decision-making, parenting time, child support, where paternity and or support are already established. So check this box if this applies to you, the date the petition was filed, information about other emergency cases involving the same parties or children, fill this out accurately. Fill out this section accurately. Indicate what you're asking the court to do. Sign. Oh, excuse me. Sign here before a notary. And that completes the motion form. This is what the proposed temporary order looks like. Pre-decree temporary order without notice for legal decision-making and physical custody. So that's all you can get on the emergency basis. Fill out your caption and then fill this out with what you're requesting. Same thing, fill this out to the best of your ability, but leave this signature part blank because that's where the judge will sign. And then you've got your order to appear regarding motion for temporary orders. This is the Maricopa County form. And then if you're in Yavapai County or some other rural counties, you may need to also do this petition for order to appear. And then here's the proposed order to appear for pre-judgment temporary orders. And this is the Yavapai County form. All right, so just to review again, the procedure for temporary orders without notice is a bit different. You file your motion, the judge makes a ruling. If the order is issued, you must serve the other party very quickly. You likely need to hire a process server. And then you'll prepare for the return hearing, conduct a return hearing. And in the meantime, you're likely filing a motion for temporary order with notice. So the next steps after filing a motion for temporary orders without notice, the court's going to review your motion and decide whether to take testimony or just to issue the temporary order based on the pleadings. If the temporary order without notice is issued, the judge must schedule a return hearing within 10 days or longer for good cause shown. Upon the judge issuing the order to appear for the return hearing, the party that filed the motion for temporary order must serve the opposing party with the motion, the order to appear, and their proposed and the temporary order. That should be on there as well. And then file a motion for temporary order with notice by the deadline ordered by the court and properly serve the papers. Be aware that a temporary order without notice expires at the return hearing. So you're going to serve the order to appear, the temporary order without notice, and the motion for temporary orders without notice. All right, so the temporary order without notice plus the order to appear for the return hearing is issued. You receive the temporary order and the order to appear. You must act promptly to complete service, serve the motion, the temporary order, and the order to appear. And you must serve as soon as possible or by the deadline set by the court, and I recommend you hire a process server. there are these various options, but there's likely not sufficient time. And if you're seeking an order without notice, you likely don't have good communication with your co-parent. So working with your co-parent to get an acceptance of service or a certified mail signature done is probably unlikely. So that's where a process server is most likely your best option for serving papers without notice. Okay. All right, so we talked about that procedure. That's different from the procedure with notice, because in this procedure with notice, the motion and the supporting documents are filed, they're served, and then the other side gets a chance to file a response. So let me add one more detail here. The motion is filed and the supporting documents. The court issues the order to appear. All of that is served. And then the co-parent gets a chance to do a response, and the filing party can do a reply. And then it proceeds to the RMC and evidentiary hearing if there's still disputed issues. So let's look at how to do a response and also how to do a reply. Okay, so here is Rule 47E. A party who is served with an order to appear on a motion for temporary orders is not required to file a response. But if the party does file a response, then they must verify the response. So they need to sign it in front of a notary or otherwise verify that all the statements in the document are true. Whether or not the party files a response, the party must fully comply with the requirements of Section F. So we'll get into that. Additionally, if the motion requests child support, the party who is served must file a completed child support worksheet. The party who is served must also provide copies of all filed documents to the assigned judicial officer and to the moving party not later than 3 days before the date set for the conference or hearing. It's going to be 3 business days. Okay, the response. So let's look at this. So what I've done here is I've put the motion and the response side by side. So here's the template for the motion, and here's what I've put together for a template for the response. And this document is attached below in Word and PDF format. So you'll be able to modify this. And all the parts that are in this red color, that's what needs to be changed. That's what you need to tailor to your case. So putting in the names of each party, the county, the case number, your contact information. Which party are you? Are you the petitioner or the respondent? So get that straight. And then we get into paragraph 1. So these numbers are going to track the paragraph numbers in the motion. So what you'll do is read through the paragraph 1 of the motion about when the petition was filed, or let's say the motion you're dealing with isn't this set form, but is either a document drafted by a lawyer or is a standard form from a different county that's a bit different. The procedure is the same. In other words, when you're drafting a response, you're going to be responding to each paragraph by admitting or denying the substance of the paragraph. So here in paragraph 1, do you agree about the date the petition was filed, the type of petition, the name of the court, information about the court hearing scheduled for the petition if one is scheduled? Do you agree with everything in paragraph 1? If you do, admit is a good answer. If you don't agree, then you can say deny, and it's helpful to indicate what about this paragraph 1 you are disagreeing with. So let's say that you disagree with the date the petition was filed. There was actually a typo, and they said it was filed on the 1st, but it was actually filed on the 2nd. So you could say admit in part and deny in part. The petition was filed on the 2nd, not the 1st. So not the most important point, but I'm just trying to give you an example of how to draft a response where you're admitting in part and denying in part, if that's what you want to do. So then this paragraph 2, information about other temporary orders. So, you'd see what was checked here. And if this is true, you know, there's no other temporary orders, there's no other court proceedings, you know, admit. Obviously, this is just some examples. This isn't tracking exactly here, but you can see my point about how you need to look at each paragraph and then respond. So this request is based on the best interest of the minor children and or on the inability of one spouse to support himself. So that's not going to apply. So you could say this paragraph does not require a response because they're just saying what their request is based on, but you don't have to agree to that. That's just their point of view. Do you agree as to the children that are subject to the order? If so, you can admit that. Paragraph 5 about jurisdiction, if you agree to jurisdiction, you'd admit. Paragraph 6 talks about their proposed parenting plan. So this is where you could say this paragraph does not require a response because they're just saying they attached it and as their position. Or you could also include that you disagree with their plan and explain why. So that's an option for you. So then they start getting into their request to the court. Now, you'll see that there's no paragraph 8 here, but there's a paragraph 8 here making a general denial. So this is a paragraph that's good to include, just saying anything not specifically admitted is denied, to make that clear. Additionally, after paragraph 8, you could start creating additional paragraphs where you could indicate what you want the court to do for legal decision-making, physical custody, parenting time, and child support on a temporary basis. So now we're in this form and you'll see there's paragraph A about temporary decision-making and legal custody. So here, indicate which party you are and tailor this part. And then for part A, you can see whatever the other side requested. And do you want that request granted or denied? Same thing for parenting time. You can see what the other side requested. And do you want their request granted or denied? So all these parts in red, you need to tailor to your case. So here, this is going to be whatever party you are. This is going to be the other party. This will be the other party, the other party, the other party. So you're saying what you want to happen with the other party's request. Do you want it granted or denied? And if you want, if you're saying denied, you can also add in additional language here saying what you want the court to order for each of these issues. C, temporary child support. D, medical, dental, vision care for minor children. And then this part E gets into medical and dental care for the other spouse. So it does not apply because we're in a custody case. Spousal maintenance support does not apply. Access to community liquid assets does not apply. Disclosure of community liquid assets does not apply. This is all divorce stuff. Payment of debts generally does not apply. There may be some narrow circumstances for hospital debts and stuff, but that's going to be a narrow exception on a temporary order. So likely does not apply in a custody case. And then exclusive use and possession of property doesn't apply. Attorney's fees, if the other side is requesting that, you could ask that the request be denied. Length of the temporary order, and then any other orders you're requesting, you would put here, date and sign. And then you can just see I'm just tracking the form. And then you'll fill out the mailing certificate. That's what this is called, the mailing certificate. And then that completes the response. All right, now the reply is very similar. So with the reply, it's the same thing. You take the response and you're going to reply to each paragraph in the response. So if paragraph 1 has been admitted, then you'd be in a position to say something to the effect of, paragraph 1 is not in dispute. And then anything that's been denied, you can indicate your position. Okay, I see now that I had respondent's current address incorrect. I agree that what respondent put for their current address is the correct address. Paragraph 3, the parties in agreement. Paragraph 4, paragraph 5. So this is where in the reply, you're really narrowing down to what's in dispute, and whatever is in dispute, making your arguments about what you want the court to do and why. And then same thing in the reply. This final part is the final request to the court. So you can just fill that out and then sign, fill out your mailing certificate, and then that completes the reply. So with both the response and the reply, depending on what you're doing, let's say you're filing the response, you're going to file it with the court, and you're going to mail and or email a copy to your co-parent and or their lawyer. Same thing with the reply, you would e-file it, and then you would send a copy by mail and or email to the opposing party or their counsel. Okay, we're in the home stretch here. Let's talk about what happens at the RMC or at the evidentiary hearing if one is set. So the resolution management conference there's a lot of things the parties are supposed to do prior to the RMC. At least 3 days before, they're supposed to get together and do a meet and confer where you try to resolve as many issues as possible. You're also supposed to file resolution statements. There's a form for that. You're supposed to exchange exhibits and witnesses, lists of witnesses 3 days before the date set for the evidentiary hearing. So keep in mind that this is for the evidentiary hearing. And then if there is a court order prohibiting contact, then the parties don't have to do a meet and confer. All parties and their counsel, if they are represented, must appear at the resolution management conference or evidentiary hearing. So look at the RMC as an opportunity to resolve disputed issues. Can you reach an agreement to resolve temporary legal decision-making and parenting time, child support? Can you resolve your issues related to the temporary order in the context of the RMC? If you can't, then any remaining disputed issues will proceed to an evidentiary hearing. So if your case gets set for an evidentiary hearing, keep in mind the court is going to set 30 minutes to an hour on the motion. So you're not going to have a lot of court time on a temporary order. Calendar the hearing date, calendar the disclosure deadline, calendar the exhibit deadline, draft your list of witnesses and exhibits, complete your disclosure, and draft your hearing outline. So you really need to start getting prepared. And then this is what your hearing outline looks like. And you can go to the trial skills series to get more information on this, but there's opening statements. And then the party that filed the motion, they call their first witness to the stand, which could be themselves. And they're going to testify. If they have a lawyer, they'll testify in direct examination. If they don't, then they'll just testify on their own. Then they're subject to cross-examination by their co-parent or their co-parent's lawyer. And then redirect is where the person testifying, the witness testifying, gets to say anything, any final things they want to say. Next, when that witness is done, then the party that filed the motion for temporary orders can present a second witness. Now, given the limited amount of hearing time that you're likely going to get for a motion on temporary orders, you may not have time for 2 witnesses. But I'm just showing you that if you do have time and you call a second witness, it's going to be the same procedure. Once the party that filed the motion is done presenting their witnesses, then the opposing party gets to present their first witness. Same thing, direct examination, cross-examination, redirect. If they have a second witness and if there's time for it, they can present their second witness. If there's time, the party that filed the motion for temporary orders could present 1 or more rebuttal witnesses. And then if there's time, there would be closing arguments and the judge would make a ruling. Now, keep in mind, if you're going to an evidentiary hearing, and there's a dispute about temporary legal decision-making, the standard before the court to determine legal decision-making is what is in the best interest of the children. So look at 25-403 and some of the related statutes around there. Look at also the case strategy creation videos for legal decision-making, because that's going to give you a lot more insight on the law that applies. Temporary parenting time, same thing. You're going to be in these custody statutes, in particular, the best interest of the minor children statute, 25-403. And then child support, what is the child support obligation or according to Arizona's child support guidelines and calculator? So we're looking, this is the law. This is if you're going to a contested hearing, you're going to want to shape your presentation of evidence around these standards. All right, we have reached the end. Let's do a summary of what we covered today. What is a temporary order? In a child custody case, you can request a temporary order for legal decision-making, parenting time, and/or child support. Within child support, you can also get an order for who's going to pay for medical insurance for the children on a temporary basis, and how are you going to divide uncovered medical expenses for the children on a temporary basis. A temporary order can be issued with or without notice to the opposing party. To qualify for a temporary order without notice, you must show irreparable harm and why notice should not be given, or what attempts you made to give notice and why you're unsuccessful. If a temporary order is issued without notice, then a return hearing is set 10 days after the issuance of the order, and you've got to serve all of the papers prior to the return hearing. If you're seeking a motion for temporary order with notice, you're going to file the motion, your proposed parenting plan, your proposed child support worksheet, affidavit of financial information, and the order to appear, along with the proposed temporary order. If you're going without notice, you'll file the motion, the proposed parenting plan, proposed child support worksheet, affidavit of financial information. And let me switch out because, and I need to correct this now that I'm going through it, you're not going to have all of these extra documents, and you can still file them and they can later apply to your with notice. But all you'll need to do for the without notice is your motion and the order and the temporary order. So the order to appear, the temporary order, and your motion. After your motion is filed, if you filed with notice, the court's going to issue the order to appear. You've got to serve the papers. Once they're served, the other side can do a response. You can do a reply to the response. You'll proceed to a resolution management conference, and then you'll go to a contested evidentiary hearing if there's any disputed issues that remain. But if you're going without notice, then you file your papers. The temporary order without notice and the order to appear are issued. You've got to serve those papers and then proceed to the return hearing. In the meantime, you can draft and file a motion for temporary orders with notice, proceed to the return hearing, and then from there, you're back in this procedure of a response, the reply, the RMC, and the contested hearing. Just realize that the response is optional. You don't have to do it. But if you are going to do a response, then you're going to want to include your proposed parenting plan, your proposed child support worksheet, and your proposed affidavit of financial information. And then the reply is optional as well. Now, with the RMC, keep in mind that you want to calendar 3 to 5 business days prior to the RMC. The law talks about 3 days, but I know in Yavapai County, their orders say 3 days. So look at your order and see what it says. But you want to provide the other side with your disclosure statement if you've got that ready, your proposed resolution statement, complete your meet and confer call. At the evidentiary, or once you get an evidentiary hearing date, if you have disputed issues that remain, calendar the date, calendar the disclosure deadline, calendar the exhibit deadline, draft your list of witnesses and exhibits, complete your disclosure, draft your hearing outline, and prepare for the hearing. All right, thank you so much. I know that was a long video today. There's so many options with temporary orders, but thank you. And if you have questions, please bring those to the Q&A.